Hey everyone, this is Mike. This is the second part of our series delving into the Fourth Amendment. A good place to begin here is by just reciting a general definition of the Fourth Amendment as it applies here to searches and seizures. The Fourth Amendment says that people should be free in their persons from unreasonable searches and seizures. Now, there are three components to this amendment that have been heavily litigated and that the courts have weighed in on in the last century. The first is the issue of search. What is a search? The second is the issue of seizure. What's a seizure? And the third is, what is this concept called reasonableness? Well, beginning with a search is defined as governmental intrusion into an area where a person has a reasonable and justifiable expectation of privacy. An easy term to overlook here is that the intrusion has to be state intrusion or governmental intrusion. These days, there are private detectives, there's loss prevention officers that work for big box companies like Walmart and Target. They are not state actors. They don't work on or behalf of the state. And so any intrusion or by them would not rise to the level of a violation of the Fourth Amendment because it's not a search. Now, moving on to the seizure. A seizure is defined as the exercise of control by the government over a person or a thing. So it's not just over the person, but it could be some inanimate object. Reasonableness. Well, this unfortunately means that we have to delve into a gray area, and this, of course, irks the general public to no end, because the question of what's reasonable under the Fourth Amendment isn't black and white. Instead, it depends on the circumstances. For example, there are certain searches and seizures that are considered to be reasonable only if the government has first obtained a warrant that authorizes the action. At the same time, there are other searches and seizures that are reasonable without a warrant. So what I'm going to discuss what I'm going to discuss now basically outlines the requirements for searches and seizures under the Fourth Amendment. Let's begin with arrests and other detentions. So generally, the governmental detentions of people, including arrests, these certainly constitute what's called seizures of the person. So they have to be reasonable in order to conform with the Fourth Amendment. Whether a seizure of the person is reasonable depends on the scope of the seizure and the strength of the suspicion prompting the seizure. So when I talk about the scope of the seizure, the question that comes up automatically in my mind is it an arrest or merely an investigatory stop? And when I speak of the strength of the suspicion that prompts the seizure, the question that comes up in my mind is are we talking about an arrest requiring probable cause, or are we talking about an investigatory detention that can be based on nothing more than reasonable suspicion? So in the case of investigatory detention, a quick and dirty example might be that of some law enforcement officers that are working in an undercover capacity. It's late at night. They're scoping out an area that is a commercial district. It's, when I say late at night, I mean it's after hours and all the shops and storefronts are closed. The officers see somebody walk up and down in front of a storefront, and the person, appears to be looking inside the window and appears to be looking around in a way to suggest that he's trying to make sure that the coast is clear. The police relying upon reasonable suspicion, might approach that individual in order to ask some questions and to find out what he or she is doing there. And there is some case law that covers that, most notably the case of Terry versus Ohio, which we'll talk about soon. What constitutes a seizure of the person? Generally it's obvious when the police arrest or seize a person that there's been a seizure of the person. When it's not readily apparent, the Supreme Court has said that a seizure occurs only when a reasonable person would believe that he's not free to leave. Generally, police pursuing a suspect does not rise to the level of a seizure. So police pursuit of a suspect generally is not a seizure, the Supreme Court found in the case of Michigan versus Chesternut. However, there have been state court cases that have found otherwise. But the gold plate rule here, as found by the Supreme Court of the United States, is that a seizure requires physical application of force by the officer or a submission to the officer's show of force. It's not enough that the officer merely ordered the person to stop. So here is a quick and dirty example. In this case, and this comes out of the landmark case of Florida versus Bostic. It was decided back in 1991. There were a group of bus passengers that were in a bus that was getting ready to depart. Officers boarded the bus shortly before it departed and asked the bus passengers for identification and consent to search their luggage. The mere fact that the passengers felt they weren't free to leave because they feared that the bus would depart without them did not make this a seizure of the person. The Supreme Court held that the test is whether, under the totality of the circumstances, a reasonable person would feel that he was not free to decline the officer's requests or otherwise terminate the encounter. Now, we have that case, and we have another case to actually compare it to help drive home this concept. The second case that we're going to use as a means of comparison is the case of Kopp versus Texas. And I may not be pronouncing it properly, but it's spelled Kaupp versus Texas. It was decided by the Supreme Court back in 2003. And here are the facts of that case. Without a warrant or probable cause, 6 police officers went to the defendant's home. It was around 3 a.m. in January. At least 3 officers entered the defendant's room, awoke him out of a dead sleep, and told him they wanted him to go and talk about a murder. The defendant answered, quote, okay, and was handcuffed and taken out of his house without any shoes and dressed only in his boxer pants. He was taken to the murder scene and then to the police station, where he later confessed to playing a minor role in the crime. His attorney tried to have his confession suppressed as the fruit of an illegal arrest, but the trial court held that the defendant had not been arrested until after his confession. And they relied on the fact that the defendant said okay, thereby consenting to going to the police station, and that he was handcuffed only pursuant to a policy that was adopted to protect officers when transporting individuals in their squad cars. So that's how the court was able to circumvent or get around this idea that the defendant was not arrested until after his confession. Again, the attorney was trying to argue that the defendant had been arrested when the officers barged into his home and awoke him out of a dead sleep. But again, the court held that his acquiescence in saying okay was consent to go to the police station, and the fact that he was handcuffed was only a mere procedure that the police had to follow when they were transporting persons to their squad cars. Well, lo and behold, the defendant went to trial and was convicted and sentenced to 55 years in prison. The Supreme Court overturned the conviction on appeal, holding that the defendant's okay was merely an assent to the exercise of police authority, that a reasonable person would not know. And I love how strong the language here is. A reasonable person would not know that the handcuffs were merely for the protection of the officers, and that it cannot seriously be suggested that under the circumstances, a reasonable person would feel free to tell the officers when questioning started that he wanted to go home and go back to bed. I mean, for crying out loud, it's 3 o'clock in the morning. The guy is in boxer pants. He's been awoken out of a sound sleep to this intimidating police presence. We don't have facts in here to know whether their guns were drawn or not, but clearly the guns were visible, and clearly there was a strong police presence. So in light of that, there is no way that a reasonable person would have felt free to tell the officers that he wanted to go home and go back to bed. Now, moving on to arrests. An arrest occurs when police take a person into custody against her will for purposes of criminal prosecution or interrogation. There is a requirement, of course, before a person can be taken into custody against their will. An arrest must be based on probable cause. And so that begs the question of what is the definition of probable cause? What rises to the level of probable cause for the police to arrest a person? Well, courts have held that probable cause is present when at the time of the arrest, the officer has within his or her knowledge reasonably trustworthy facts sufficient to warrant a reasonably prudent person to believe that the suspect has committed or is committing a crime. And of course, that's a mouthful, and every term here is a term of art that lawyers have, extended great meaning to. And when I say lawyers, I mean the Supreme Court, the lawyers who sit as justices on the Supreme Court of the United States. So to boil this down, again, I'm going to repeat the definition and then provide you with an example out of the case of Maryland versus Pringle. But probable cause exists when an officer has within his knowledge reasonably trustworthy facts that are sufficient to warrant a reasonably prudent officer to believe that the suspect has committed or is committing a crime. In the case of Maryland versus Pringle, the defendant was the front seat passenger of a car that was pulled over for speeding late at night. There were other occupants in the car, not only the driver, but I believe there was a second passenger in the back seat. The officer asked the driver for consent to search the car. The driver gave the officer consent to search. Lo and behold, the police found about $800 in the car's glove compartment and several bags of cocaine hidden in the back seat. As is often the case, no one admitted ownership of the cash or the drugs, and under the circumstances, the police had probable cause to believe that the defendant, who in this case was the front passenger, was seated in the front passenger seat, committed the crime of possession of cocaine. So in other words, the police had probable cause to arrest the defendant as well as all of the other occupants of the car, believing that that one or more of them had committed the crime of possession of cocaine. So that's why it's very frequent for the police, when they conduct a motor vehicle stop, and find something illegal in the car to charge everybody from the driver all the way down to the backseat passenger with whatever was found in the car. And the courts have held that probable cause exists for such an arrest. Now, mistaken offense. Here's an interesting concept that comes up. Just because an arrest is invalid because the grounds stated for the arrest at the time it was made are wrong, as long as the officers had other grounds on which there was probable cause for the arrest, then it's a clean arrest. So that's a long way of saying that an arrest is not invalid merely because the grounds stated for it at the time it was made are wrong, so long as the officers had other grounds on which to base their probable cause for the arrest. So again, it's a mouthful. Here's a quick and dirty example out of a case called Devenpeck versus Alford, Supreme Court case. Police officers pulled the defendant over on suspicion that he was impersonating an officer because his car had police-type lights. They found his answers to their questioning to be rather evasive. Upon discovering that he was taping their conversation, yes, the facts state that the defendant was in fact taping the conversation, the police arrested him. And they arrested him erroneously thinking that the taping violated a state privacy law. Well, there was no such state privacy law that was being violated, and essentially the defendant had every right to tape the conversation, and so the issue here becomes one of whether the police could still make this arrest based on the fact that they erroneously believed that the defendant had violated a state privacy law. And the court held that so long as the officers had probable cause to arrest the defendant for impersonating an officer, the arrest was valid. It doesn't matter that they lack probable cause for the offense they said at the time of the arrest. So essentially, the fact that they were wrong, the police were wrong in basing their arrest on this idea that the defendant violated a state privacy law is meaningless, because they had another basis on which to arrest the defendant, and that was for impersonating an officer because his car had police-type lights. And again, the rule of law here is that so long as the police had probable cause to arrest the defendant for the substantive offense of impersonating an officer, the arrest is valid. It doesn't matter that they lack probable cause for the offense that they articulated at the time of the arrest, which was the violation of a state privacy law for taping the conversation. Now we're going to move on to situations where a warrant is generally not required. So in contrast to the rule for searches, police generally do not need to obtain a warrant before arresting a person in a public place, even if they have time to get it. So I cannot stress or emphasize that enough. Police do not need to obtain what's called a body warrant to arrest a person in a public place, even if they have the time to get it. And there's what we do here is we distinguish between felonies and misdemeanors. With respect to felonies, a police officer can arrest a person without a warrant when he has reasonable grounds to believe that a felony has been committed and that the person before him committed it. When it comes to misdemeanors, an officer can make a warrantless arrest for a misdemeanor committed in his presence. And the key phrase here is committed in his presence. A crime is committed in an officer's presence if he's aware of it through any of his senses. So the police may make a warrantless misdemeanor arrest even if the crime for which the arrest is made cannot be punished by incarceration. There is a big exception here, and that is triggered when it comes to home arrests. Home arrests flat out require a warrant. And the rule of thumb here, the bright line rule, is that police must have an arrest warrant to make a non-emergency arrest of a person in his or her own home. All warrantless searches of homes are presumed unreasonable, and the burden is on the government to demonstrate sufficient emergency, or what we call exigent circumstances, to overcome this presumption. Now, how about the homes of a third party? What if the police are executing an arrest warrant on a person who is, for example, staying at a guest's house or the home of a third party? Well, the court held in this case of Stigald versus United States that absent exigent circumstances, the police executing an arrest warrant may not search for the subject of the warrant in the home of a third party without first obtaining a separate search warrant for the home. So if they have an arrest warrant, the police, that is, have an arrest warrant for John, and John is staying at his friend Jennifer's house, the police can't just arrive at the doorstep of Jennifer's house without a search warrant and attempt to execute the arrest warrant for John at Jennifer's house. They can't do that absent exigent circumstances. What they would need to make it clean and to make it legal is to at least obtain a separate search warrant for Jennifer's home before they enter Jennifer's home and arrest John on the search warrant. So what is the effect of an invalid arrest? Well, an unlawful arrest by itself has no impact on the future criminal prosecution. So if the police improperly arrest a person at his home without a warrant, for example, they may detain him if they have probable cause to do so. And the invalid arrest is not a defense to the offense charged. However, that comes with this caveat. The evidence that was uncovered as a result of the unlawful arrest can't be used against the defendant at trial because of the exclusionary rule, which we'll get into in a future podcast.